Hi, I'm Debbie Moraes, and this is Legal Matters, the program that's designed to address critical, sometimes controversial issues facing consumers and businesses today. It's legal information, it's practical solutions, and it's straight talk about a wide variety of topics, and it's been business and family law, and today we're going to be focusing on family law. In the practice of family law, the frequency of child removal litigations certainly been increasing exponentially. It's been in the news. And we all read about the number of corporate downsizing and business mergers and acquisitions and the general growth of in employment and mobility, and it's certainly impacted children. And today we're going to focus on that. In fact, in the newspaper, I'm sure many of you have been reading that there have been issues about child abuse relative to child removal. Right now we're going to be focusing on the issues that most affect families, and with us to discuss, once again, we welcome, from Odette Bizarre-Cordero Grasso Law Firm in East Providence, Jackie Grasso and David Bizarre. So it's a very critical issue, and I'm glad that we're having a chance to talk about it today. Broad brushstrokes, is there formally a removal statute per se?
You know, David and I were just talking about that. There isn't a statute in Rhode Island, nor is there Mass. It's primarily based on case law.
Right, and we've talked about the difference between statutory law, which is created by the legislature, and case law created by the Supreme Court. And there's a couple of leading cases in Rhode Island on children and custody, and when you say removal, there's a couple of different things that you can talk about when you say removal. One of them would be removing a child from a parent's house, and the other thing is when a parent wants to remove the child from the state. They're two very different things, and there's different case law in each of those.
Where would you like to begin? I suppose it's easy to, well, what's the easier thing for you to begin with?
Well, why don't we start with the seminal case in Rhode Island, which is Pettinato versus Pettinato, and how that links into Dupre versus Dupre and the removal. That's removal
of the child to another state.
Voluntarily.
And what we're starting with, and we've talked a little bit about this before, is placing a child with one parent or the other when there's a divorce. That's Pettinato. That's the case that established the guidelines or standards that a court should look at in determining what is in the child's best interest in deciding where that child should live.
Now, excuse me, was it a sole custody or was it a joint custody issue?
Well, there's two different types.
It's really a physical placement issue.
You have sole custody, or when somebody says you have joint custody, really what they mean is joint legal custody, which is the ability of each parent to partake in major life decisions for the child. When you have joint physical placement, that means they're residing in both homes.
It's a shared custody,
equal time.
Shared placement.
Yeah.
When I first started, the older judges never heard of anything other than the child goes with the mother.
That's right.
There was a tender years doctrine. A young child especially belongs with his or her mother, and that's where children went. So I had a case in front of one of these older time judges, and I said, well, we're not looking for physical placement, we're looking for joint custody, which to us then meant that the husband in this case, because that child was going with the mom with this judge, that the husband had the right to talk to the schools, the doctors, and have input in how the child was raised. That's joint legal custody. Once the judge got that, we tried to take him to the next level, which was joint shared custody, shared physical placement. Oh, that was never happening with that judge. How can a child not have one home? And what we found was that a child is okay with knowing that he's going to be in one place one time, another place another time, as long as there was consistency. That was what the child really needed to know. If it's Tuesday, Thursday, Wednesday, whatever it is, I'm with Dad. If it's the other days, I'm with Mom. Just need to know where I'm going to be day to day.
And the court needs to make sure that it's well-intentioned as well. And sometimes what they're leery about is a parent wants joint physical placement for the sole reason of avoiding any financial obligations, i.e. child support. So they're usually a little skeptical about that. And again, we go back to the standard, you know, what is the best interest of the child? What's the relationship of the child with the parent? So on and so forth.
Go ahead.
You mentioned that judge, whoever that judge was. So that brings up an issue about some subjectivity here. And I was about to say, is much of this then dependent upon, I don't know, how good your lawyer might be or how good your relationship is with the lawyer and who you might have or be able to have in state of Rhode Island or state of Massachusetts to get a better judge who's going to be more favorable to your case?
What
Is that an issue?
what we just did was lay out some of the different types of
Yes.
issues. Now you're getting into more of the specifics. Two parents can't agree on where the child should be placed. And that's where you get into this patinato issues, the standards
Yes.
laid out in that case. And there are several of them, but the overriding factor is what's going to be in the child's best interest. And we can go specifically into some of what those issues are that might make a court decide one way or the other as to what's in that child's best interest.
Just for instance, in some cases, if the two parents cannot communicate at all about anything, can't agree on anything as it pertains to the children, even things during their marriage, if they can't agree, if they don't get along, if they have different parenting skills, the likelihood of getting joint physical placement, I think, is going to be far less than two parents that can parent together, co-parent, and they have very good communication skills, and they both have great relationships with children. So again, it's an individual case base. It's also somewhat subjective in terms of the judge looking at it as well.
And that's the part that's subjective.
Exactly.
Would lawyers actually present as part of the case, we believe these two can co-parent in the same location and advocate together and then try to enlist the judge's support that way? Is that what happens?
Sure, and different judges are going to look for different things that are important to them in some ways. How old is the child? What is the relationship of the child with each parent? What is the parent's relationship with each other? Which parent's going to encourage the other parent to have a relationship with that child? The court wants to place the child with a parent who's going to be best suited to raise that child, number one, but more importantly, not more importantly, but as importantly, who's going to encourage that child to have a relationship with the other parent more. If you've got equal parenting skills and equal reasons, that might be the one that flips the judge one way or the other as to who's going to have the child. And then there's a whole host of other things that can come into it, from religion and that type of decision, you know, what has been brought up and talked about before, to where's each parent live and what school system might the child be in?
Yeah, if somebody lives in Woonsocket and the child goes to school in Narragansett, is joint physical placement going to work? Clearly, I mean, Rhode Island's small, we know we can drive through it in an hour, but for a child of a young age to have to go back and forth, if the child goes to school in Narragansett, well, when he's in Woonsocket with the parent, that's going to pose more of a difficulty than when he's in Narragansett with the other parent.
Now, you bring up an interesting point. Say, for example, when you mentioned earlier about sometimes this being a financial issue, if you were talking about Woonsocket and Narragansett, would a judge tend to favor the parent who's more likely to raise the child in a school system? Say, for example, currently, the school system in Narragansett might be better than Woonsocket or Central Falls. Would that weigh in on, and should it weigh in on, where that child is ultimately going to be placed?
Absolutely not. Then I think you get into politics there, where the judge is ultimately saying, I don't think this city has a good school system, so therefore you should go to this school system. That is not one of the standards they
You're starting to walk a fine line there.
Exactly.
Because if one parent has a boatload of money and the other one doesn't, and they could make an argument that, well, this child's life will be much more enhanced by living with, quote-unquote, the wealthy parent. The court's never going to look at money, per se, as to decide where a child should live. The school system becomes a more interesting issue. It's it may not be the deciding factor, but it could be, I'm not going to say a tiebreaker, but something that at some point gets factored in.
I've had a couple cases where I've litigated where actually I had it was a joint physical placement. It was working out great. The arrangement was working out great. One party lived in Fall River, the other party lived in Rhode Island. After we got over the jurisdictional hurdle, the remaining issue in the case and the divorce was, what school system are they going to put the child in? Well, the father who lived in Fall River says, I want to put the child in Fall River Public Schools. My client who lived in Warwick, had the child enrolled in a Catholic school where the child had been going for like 3 or 4 years. So again, you go to what David said, what's in the best interest, what's the consistency there, are they able to afford being in this particular school? So it wasn't so much the money factor or what school is better, it was so much, it was more of what is going to be more remain consistent in this particular situation.
If a child's been in a school for a period of time, you
that's
don't want